hold the President to account because it failed to properly consider the content of the report, then that might trigger the exclusive jurisdiction. This is the more narrowly and described. If the complaint must relate to a specific constitutional obligation of the Assembly, then this is not a specific constitutional obligation of the Assembly.
Perhaps then it's because I'm looking at it holistically, because I'm looking at the fact that the real complaint is that as a result of them not considering the report, they failed to hold the President into account.
Yes.
And this is why I then thought that then we have exclusive jurisdiction,
yes,
because the real complaint is that had you considered the report, you would have held the President.
Yes, I understand that, Justice Chiki. I understand with respect to the point that you're making. And if it is formulated that way, then it may trigger the exclusive jurisdiction. But as you say, we have to have regard to the pleadings as they stand, and the pleadings as they stand don't make that case. They make a different case, which is that the Assembly failed to hold the President to account. They make that elsewhere in their founding affidavit. That triggers your jurisdiction. But the fact that the allegation that the National Assembly didn't properly consider the matter before it doesn't trigger, I submit, the exclusive jurisdiction of this court.
Mr. Butler, we've heard wide and varied submissions, quite critical of the panel, both during oral argument this morning, and one can find much more evidence of that in your client's affidavit. And most of it, there's a basis for it. But it seems to me that looking into the future, it might always be quite easy to impugn a report of an independent panel for reasons not associated with the expertise of the panel, their diligence, or their industry, simply because of the convoluted manner in which the rules have been devised. So what the rule says is that the panel must conclude that there's sufficient evidence to show that the President has committed a serious misconduct, a serious violation of the law, etc. But then, having charged the panel with producing a report that contains sufficient evidence, it then restricts the panel considerably, because what the panel will receive only is information. Only information from members. It may not conduct an oral hearing, and it's limited to the written and recorded information placed before it. So it can't undertake what it's criticized for not doing, which is the proper evaluation of this information and to convert that information to evidence. Because ultimately, it cannot rely only on information. That information has to be elevated to evidence. And that would require some verification of that information. And so one almost senses the anguish of the panel. If you look at paragraph 94
Yes.
in volume 2, and that's at page 98. And while the panel is referring to Mr. Fraser's statements, I think they may well be a reflection of its general frustration. It says, while Mr. Fraser's statements provide information that may help to verify the truthfulness or otherwise of his allegations, the present process does not permit the panel to investigate these matters. So it has this information, but it may not investigate them. This, of course, does not mean that we must blindly accept the information contained in Mr. Fraser's statements in the hope that it may and probably will be verified. Nor does it mean these allegations must be ignored. So it sets up the two positions that it finds itself in. And then finally it says fairness dictates otherwise. But sadly, that otherwise is not to be found in the report. And so this may be a reflection of a structural difficulty.
Yes.
That panel bring us evidence,
Yes.
but you're confined to information. And the panel tries to grapple with this at 94 but doesn't seem to provide an answer to it, except to suggest that the answer lies somewhere else.
So
would you agree that that's
I
a
do
systemic
agree
issue?
that. I do respectfully agree with that approach, Justice Colopin. It seems to me the panel is given a difficult job because it's required to make findings about sufficient evidence when it's not really given all the tools which are necessary to find sufficient evidence, and then it has a finding which can have far-reaching and cataclysmic consequences. And so it's the Commission's, the panel's job is a very difficult one. And when we criticize it, we do it recognizing that. But the criticisms really don't go to the question of whether the panel did the best it could under the circumstances. That's not the issue. Or even whether what the panel found was right or was wrong. The question is whether the Assembly, when it decided not to accept the recommendation and said, well, I see all these problems in this report, was entitled to do so. And we say it was entitled to do so. It was not for the Assembly to say, well, the panel's job was a very difficult one, so I will overlook the many criticisms you could make of its report. That's not what the Assembly was required to do. The Assembly is making a decision about whether the President will go on trial. And it has to say to itself, is there a basis for that, a sufficient basis for that? And it's not, and the question is not whether the panel was right in what it said, and not even whether the Assembly was right in the decision it made. It's whether it was the decision that the Assembly was entitled to make. It had to exercise a judgment, a discretion. Did the decision it made fall within the reasonable range of what an Assembly could do? And we say yes, because there were these criticisms. Not a question of blame and pointing fingers. It's just there's a reality. The panel has to deal with the reality that the structure's awkward. The Assembly has to deal with the reality that there are problems with the report as a consequence. And it's entitled to say, well, I'm afraid this is not enough.
I accept that, Mr. Butler, and perhaps even in the context of this case, that may well be an outcome that is almost unavoidable, perhaps.
Yes.
But does it not raise the problem that the Assembly is entitled to say that this report is flawed in these respects, but in truth and reality, the origin of those flaws are the rules that the very same Assembly.
Yes, that's true.
So, you know, it's almost like, well, you can't have both your cakes and eat them. But what is your suggestion in